Okay, good evening, people. Unfortunately, I have to start off by shouting at you. I don't want to do that. And I realize I'm also shouting at the wrong people at the moment. But please, you are senior students. I shouldn't have to tell you this by now. Do not start your own class. I will start the class and I will share the link on the WhatsApp group. You wait until I have shared the link. Okay, let me just, there's total confusion here now. Just wanted to reply to your WhatsApp. When I went into Teams today, like 10, 15 minutes ago, somebody had already started an ITL class. And one or two other students had also joined. So they are now literally, and I joined that class and told them to please leave. So there are now two links to two different classes happening, one with a lecture and the other one without a lecturer. Do not start your own class. That is my job. I am the lecturer. Next time somebody starts their own class, I will let them take over from me and do the teaching. Also, please do not record the class. Do not start the recording. That is similarly my job. I will start the recording when I'm ready to start the recording. It makes it more difficult for me to download the eventual recording, and then there's different recordings, and it's just chaos. I am in charge of this class. I am the lecturer. Please respect that. Okay. Having now shouted at all of you, before I start teaching, I just want to do something here. My absolute favorite person, just switching my camera on for a moment. My absolute favorite person has come to visit me. Just tell them what your name is. Her name is Zanelle, and she's my little granddaughter. How old are you?
6.
6 years old. Where do you go to school?
St. George's.
She goes to St. George's, and she's the cleverest little thing I have ever met in my life. She's my absolute. Say hello to Zanelle quickly before we start the class.
Hi, Zanelle.
Hello. Okay, right. Okay, now I must teach. Okay, thank you. Sorry, I just had to do that quickly. She is, as I said, my absolute favorite person in the whole world. And likes to say hello to my students and just wish you all well as well. Okay, so as I explained on Monday, for some odd reason, my brain was obviously not entirely functional when I prepared the course outline and determined the schedule, because we had to rush to get through the law of contracts. And now that we're doing purchase and sale, we're actually ahead of schedule. We were only supposed to do Unit 8 this week, but we finished the whole of Unit 8 with ease on Monday. So I'm going to, and then we do Unit 9 next week, which we can also finish quite easily. It's 10 pages, but it's not, okay, there's some substance to it. So I'm going to start with Unit 9 Tonight, I won't keep you well. How long I'm going to keep you depends on sorry, I just want to share my screen. How long the class takes will depend on how much discussion there is and how many questions you have. A word of warning, as I seem to have been giving every single time I teach so far, namely, I'm having some bad rain, heavy rain at the moment at my house where I'm conducting the class from. And bad weather sometimes interferes with my connectivity. If I go offline, we'll handle that. Okay, so what we've done so far is we've looked at what is a contract of purchase and sale. We've learned that contract of purchase and sale is a mutual contract for the transfer of possession of a thing in exchange for payment of a purchase price. Or another definition, a contract in terms of which one person undertakes to deliver a thing and the latter undertakes to pay the price. So there are always at least two parties involved. It is a reciprocal contract. You cannot enter into a contract of purchase and sale with yourself. Keep your mics off, please. Please keep your mics muted. I've got some background noise. I know can't see who it is, but keep your mics muted, please. So there's always at least two parties involved, a purchaser and a seller. Then we learned also on Monday that different types of contracts have different legal consequences, implied terms of the contract that will always apply unless they are expressly excluded. So in Unit 9, we look at the duties of the parties. The duties of the various parties to a contract of purchase and sale. These duties are not the only duties. There can be duties that are incidental, that the parties can arrange between themselves. These duties that I'm referring to are duties, natural legal consequences, implied terms. They will always apply. Now, there are a number of them. Tonight, I want to just look at two of them, namely the duty to deliver and the duty to guarantee against eviction. I'm going to do both of them tonight because they are very much linked to each other. So the duty to deliver. That the purchase seller, these are, sorry, I should have mentioned this. So I said we're doing the duties of the parties, starting specifically with the duties of the seller. And then afterwards, once we've looked at the duties of the seller, we will look at the duties of the purchaser. So the seller has the duty to deliver. That is actually apparent from the definition. One person undertakes to deliver a thing. So it's literally right there in the definition that the seller has the duty to deliver the thing. However, as I pointed out to you in previous lectures, sometimes words, English words that we use in law have a specific meaning, which is not the usual English meaning. We spoke about that when we were talking about an option. Normally in English, you'd say an option is one of two choices, but an option in law is a contract to keep an offer open for a specified period of time. And the term to deliver, delivery, has a different meaning from the manner in which we use it in English. Because when we use the word deliver in ordinary English, I bet you most of you are thinking that you're delivering the things. In other words, the seller is taking it to the purchaser. But that is not the meaning of delivery in legal terms. Delivery in legal terms means that the seller must put the thing deliverable state so that the purchaser can take free possession of it. Another meaning of delivery is that the seller must give the purchaser free. And by free, it doesn't mean free of charge. Free doesn't relate to money here. It means make it available. Which now should actually make sense to you. If you go to a shop like Incredible Connection or wherever, or Game or whatever, and you go and buy a huge widescreen, big screen television set, which doesn't fit into your car. So you ask them, can you deliver it for me? And they say, yes, but that will cost you an extra $200. Have you ever thought, why do they charge you to bring it to your house? Because if the seller has the duty to deliver, then surely they can't charge you for it. No, it doesn't work the way. The duty to deliver means they get it out of their storeroom and put it there for you so that you can put it in your car. If they have to put it in a vehicle and drive it to your house, that is an extra thing that they're doing for you, which is why they're allowed to charge you for it. So delivery doesn't mean taking it to the premises of the purchaser. It means putting it in a position where the purchaser can collect it, so to speak, can take free possession of it. What happens? What happens if the seller does not deliver the thing, think a little bit. We did the law of contracts, and I pointed out to you on Monday when we moved on from doing the general principles of the law of contract to specific contracts, namely, firstly, the contract of purchase and sale. I explained to you that the law of contracts that we did so far applies squarely to purchase and sale. So, breach of contract. One of the contracting parties does not perform in terms of the contract. Somebody tell me, if the seller does not deliver the thing, what is the legal position? This is a duty in terms of the contract. So if the seller doesn't perform their duty, what is the legal term that we use for that? Come on, people, work with me. Breach of contract. Thank you, Anna. Not that difficult. So if the seller does not deliver, it is breach of contract. What type of breach specifically this is will depend on the circumstances. I didn't give you enough facts now to answer that. If you were supposed to deliver on Friday and by Friday it hasn't delivered yet, that's a delay in performance. That can be mora debitoris. On the other hand, if he's delivered on time, but not delivered what he's supposed to do, delivered something that's damaged, whatever, that can be defective performance. I'm not asking you right now to identify the specific type of breach. I just needed you to realize that non-delivery equals breach of performance. What will our remedies be in this instance? Specific performance, and order that the thing be delivered, that the seller does what he or she is supposed to do. And if in the process there were any damages, seller will have the necessary, the purchaser will have the necessary claim for damages. Any questions about this? It's fairly straightforward. Any questions? Coupled with the duty to deliver is the duty to against eviction. We touched on this on Monday, and I said I am getting to get back to this. There were some questions relating to this, if I remember correctly, specifically from Heiko. He asked some questions relating to this, and I said, don't worry, I will get back to you. So the seller's duty to guarantee against eviction. This is very important. We learned that the seller does not have to be the owner of the thing. If the seller is not the owner, it's a generally accepted principle in our law that nobody can pass on more rights than they have themselves. So if the seller is not the owner, then the seller cannot pass ownership to the purchaser. So seller is not owner means the purchaser cannot become owner. That is a common, very easy to explain principle of law in general, that if you only have a certain number of rights, if you only have 5, you cannot pass on 10. It's as simple as that. So it follows then that not in every contract of purchase and sale will the purchaser become the owner. So when will the purchaser become the owner? When will the purchaser become the owner? When the seller is the true owner, and coupled with that, if it is the intention of the parties. So ownership, the passing of ownership, is not a natural legal consequence or a natural result of delivery. A contract of purchase and sale only gives you the right to delivery, not the automatic right to ownership. Put this in here. Contract of sale only right to delivery, not the automatic right to ownership. Ownership will, as I've said, will only pass if the seller is the true owner and if it is the intention of the parties. Now, the true owner has an ownership action. They can evict. By evict here, I mean take the thing away. By evict in this context doesn't only mean you're renting a place and you didn't pay your rent and now you're being put out of the place that you rent. Evict in this context means taking possession. So the true owner has an ownership action. They can evict a person who's in possession of their property. So they can literally take it back. But now the question might arise to you, why would you then buy something? Why would you enter into a contract of purchase and sale if there is a possibility that you can be evicted and not have the thing? Doesn't that mean that a contract of purchase and sale is a risky thing to enter into? This is where the law steps in. And the seller, coupled with the seller's duty to deliver, the seller guarantees, and this is a tacit guarantee, put it like this. The tacit, with every purchase contract of purchase and sale, there is a tacit guarantee against eviction. What on earth does that mean? Tacit guarantee against eviction. It's tacit, it's implied, it's unspoken. When you buy something, if Evelina buys a cell phone from Benjamin, when they enter into this contract of purchase and sale, Evelina doesn't have to ask him expressly, Benjamin, do you guarantee that the true owner won't come and take it back? They don't have to discuss that. It's implied. It's a tacit guarantee against eviction. Tacit guarantee against eviction automatically forms part of contract of purchase and sale. What does it mean? Seller undertakes give the purchaser undisturbed possession of the thing. The seller undertakes to give the purchaser free and undisturbed. So the seller, in terms of the guarantee against eviction, the seller guarantees that nobody with a better title in other words, somebody with a better title, in other words, the true owner, that nobody with a better title will come and take the thing away. I'm going to put this here in ordinary English. So, although the contract of purchase and sale does not guarantee transfer of ownership, that will only follow if the purchaser is the true, or the seller is the true owner. It, as a natural legal consequence, guarantees that the purchaser will not be evicted, that nobody will come and take the thing away from them. This guarantee, as you can see, protects the purchaser. In order to rely on the duties, in order to rely on this guarantee against eviction, the purchaser has got certain duties, certain things that they have to do. These are discussed on page 45. namely, the purchaser must try to keep the thing in their possession. So if you've bought something and you've taken delivery and some random person comes and says, no, that's mine, give it to me. You mustn't just say, oh, okay, and then think, but you can get your money back from the seller. You must try to keep the thing in your possession. What this boils down to, only hand the thing over if the person trying to evict you, if there is proof. So they can't just come to you and say, well, that's my cell phone, give it to me. They have to prove that it's actually your cell phone. In order for the purchaser or the seller to come to your defense, you must notify the seller. You must tell them that, call them, whatever, get hold of them and say, look, there's attempted eviction here, you need to come to my assistance. If the seller does not come to assist, you must stand up for yourself. Defend your position. All means. Your disposal. This does not mean that if the police come with a warrant or court order saying, okay, there's a court order, we need to repossess this thing, that doesn't mean you are then expected to break the law or get into a fist fight with the police or whatever. But you should not just, the moment somebody says that's mine, hand it over. You must defend your position. The duty of the seller is to come to the, firstly, to guarantee that there won't be eviction. If there is an eviction, to come to the purchaser's assistance. Now, there are certain instances where this guarantee against eviction will not apply. The following instances, the guarantee against eviction will not apply. Firstly, if the parties have expressly agreed to exclude it. Remember, just to remind you again, this is a natural legal consequence. We saw here. Let me just find that. So I had it somewhere here in my notes. I just want to show you that again so that you can keep on making the necessary connections between past work. Remember, every lecture, all the work we do, everything ties up together. So you must keep on making the links. I had this somewhere. There you are. That's what I was looking for. Different types of contracts have different legal consequences, different implied terms. That will always apply unless expressly excluded. Same with this guarantee against eviction. It will always apply unless the parties have expressly agreed to exclude it. Now, your common sense should tell you that this isn't something that's going to happen very often. If Evelina approaches Benjamin to buy his cell phone, and Benjamin says to Evelina, okay, Evelina, you can buy my cell phone, but I cannot guarantee that somebody else won't come and claim ownership and take it away from you. And I want you to waive your right. I want you to agree that if somebody comes and takes it away from you, you won't claim anything against me. Evelina, in that instance, are you going to buy the cell phone? Heiko, you're very quiet tonight. Somebody comes to you and says, you can buy my cell phone, but I want you to agree that if the true owner comes and wants it back, you won't ask for your money from me or do anything against me. Are you going to buy that cell phone?
Pardon, repeat the question again, ma'am.
Okay, somebody has said here no. I'm trying to illustrate the situation that parties can agree to do away with the guarantee against eviction. They can agree that in the event of the purchaser being evicted, the purchaser will not have a claim against the seller. But I'm trying to illustrate that in real life, it's unlikely that this is going to happen. Because, Heiko, if somebody comes to you and says, you can buy my phone, but if somebody else comes and repossesses it, then you must agree not to claim from me. Are you then going to buy that phone? Heiko?
No. No.
No, of course not.
But the thing is, the problem, however, is contractually put down, and you've signed for any funny things, then unfortunately it will be of action.
Yes, but okay, first of all, let's recap. This guarantee against eviction is an implied guarantee. It's not something that has to be in a contract. It applies in any event, and try to get away from saying you've signed for something, because not all contracts are in writing. This can be an oral contract, but the guarantee against eviction will still apply. If the seller does not, okay, Evelina says buy at own risk. I'm going to get back to that buying at own risk. I just want to pick up with what I was saying. Please mute your mics if you're not specifically answering questions or talking to me. This guarantee against eviction always applies. If the seller doesn't want it to apply, it has to be expressly excluded. So they have to literally say to you, Heiko, I want you to do away with a guarantee against eviction. I want you to agree that if you are evicted, you will not claim against me. Quite frankly, I don't know why you're all baffled about this. Is that not incredibly suspect? This isn't buying at own risk. This is somebody literally saying to you, I'm not guaranteeing that somebody else will come and take it away and you can't claim against me. They are literally implying, making it clear to you that they are not the true owner. So this is not buying at own risk. This is literally being stupid. So yes, you can agree to do away and buy at own risk, so to speak. But it has to be expressed that you're buying at own risk. It's not something you're being bamboozled into. And this is one risk that if somebody is literally telling you, look, I'm prepared to sell this to you, but I'm not guaranteeing that to you that it belongs to me. This can be illegal. I suppose, yes, it can be illegal, but remember, as we learned, that this, and this is important that you understand this, saying it again, think with your heads, not with your hearts. I've pointed out to you that the seller does not have to be the owner, and that contract will still be valid. It has to be valid because it's a valid contract, it protects the innocent purchaser. A void contract is a nothingness. There are no rights and duties coming from a void contract. So if this contract isn't valid, it doesn't protect the innocent purchaser. So it has to be valid for the law to give you protection. Please get your heads around that. I know your hearts are telling you it doesn't make sense, but if you think about it carefully, it makes a lot of sense. So it will not apply if the purchase parties have expressly agreed to exclude it, but it's unlikely that it will happen. It will also not apply if the purchaser is aware or should reasonably have been aware. The purchaser is aware that the seller is not the owner. So if you know you are buying stolen stuff, then literally you are buying it at your own risk and the law will not protect you. Or if you should reasonably have known. So somebody approaches you, you're at the service station putting petrol in your car, and some very dodgy looking dude comes to you and is prepared to sell you an iPhone 15 for $500. Either it's a fake phone or it's a stolen phone. Buy that phone for $500, buying it at your own risk that either it's a fake or at some stage the police are going to come and say, no, that was stolen, give it back. And then you will not be able to claim your money back. And then also, but this is rare, the purchaser will not be, the guarantee will not apply if the purchaser, or if the eviction is not the fault of the seller. Example of that would be expropriation of land. So you've bought a plot of land from somebody, and sometime later the government contacts you and says, okay, but this is actually a road reserve and we're going to expropriate, we're going to take a piece of your farm to build a road over it. In that case, you will not have a claim against the seller. You will, however, have a claim against the government, but not against the seller. So what are the remedies once again, this is a term of the contract. The purchaser has the duty. It's one of his obligations. Purchaser has the duty to guarantee that the seller will not be evicted. So if the seller is evicted, what is the legal situation? It is breach of contract. He did not fulfill his duty. Seller undertook to give the purchaser free possession, and now he doesn't have free possession. In other words, it's breach of contract. What are your remedies? The usual remedies for breach of contract. In this instance, it's unlikely that it will be specific performance, because specific performance would mean that the seller has to give the purchaser possession of that thing. But if that thing doesn't belong to the purchaser and the true owner took it away, it's likely not possible. Specific performance is likely not possible. So instead of specific performance, we will have cancellation, and cancellation also means you get your money back. And if you can prove that you suffered any damages, you will have a claim for those damages. So, as strange as it might have seemed to you, that purchase and sale does not automatically come with a guarantee that you will become the owner. The law of purchase and sale does protect you. It does protect the innocent purchaser, that in the event of them not being able to keep possession of this thing, that they will be able to get their money back and claim damages. Any questions about that? If we have no questions, then we can end here. I don't want to do more than this tonight. We still have the whole of next week. Okay, thank you very much. Bye.
Thank you. Bye.
See you. Okay, see you in class next week on Monday. Bye.
Bye, Miss.